of the bail petition. Same. Hmm. Yes. It's the same. So I think interim was okay. But lost by a different person. That. Hmm. I will reflect it. That's okay. And I got to follow. Yeah. 1, 2, 3, 4, 5, 6, 6. Stop. The petitioner was granted interim bail on 11/3/2026 upon prima facie satisfaction that both the FIRs were arisen out of the same allegations and the same incident. And after noticing the settled principles in the case of T.T. Anthony versus State of Kerala, as reported in so and so. In terms of this law, in terms of this case law, it is well settled that there cannot be more than one FIR with regard to the same incident. Unless they are by way of cross cases, and that any subsequent information from the same side uh, could would be in the nature of a police statement. The case diary has been received along with a bail objection. Only one case diary. We had called for 2 case diaries, 22 and 23, but one has come. One. We had called for 2 case diaries. Anyway, it's the same thing. The case diary has been received along with a bail objection. One case diary only get clear. Case diary is received pertaining to Azara PS case number 23 of 2026. It has come to notice that Azara PS case number 22 of 2026 was registered based on an FIR dated 27/2/2026, and a copy of the same has been annexed at page 37 of the bail petition. From perusal of the said FIR, it is clear that both the FIRs pertain to the same incident, and lost from the same side. Cross can be there, but same side it only by a different person, by different persons. As already mentioned earlier in this order, with regard to Azara PS case number 22 of 2026, the petitioner were released on bail by the learned court below, by order dated so and so. Which is the order, madam? Yes. Order dated 28/2/2026, passed by learned IC CGM Kamrup Mirpur. CGM, learned CGM Kamrup Mirpur, Gauhati, mainly on the ground of non-compliance with the statutory notices required to be given at the time of the arrest. Full stop. This is Hussein, learned counsel for the petitioner, submits that, as per their definite instructions, other co-accused in connection with Azara PS case number 23 of 2000. Yes, sir. Instruction. I've seen instruction. Okay. As for instructions, the co-accused of the case of the present case have also been enlarged on bail. Your instruction. In the given facts and circumstances, it appears that prima facie, both the cases have arisen out of the same incident, and perhaps the second FIR may be required to be amalgamated with the earlier one in due course of law. In due course, there's a prima facie. I cannot say. I've also seen the progress of investigation revealed by the case that there is some progress in the investigation. In the given facts and circumstances, and in the backdrop of the above discussion, I'm of the considered opinion that it will it would not be in the interest of justice to cancel the interim bail, which was granted upon prima facie satisfaction vis-a-vis the principles laid down in TP and PIN. According in such view of the matter, the interim bail so and so it's hereby made action subject to the conditions subject to the following conditions. Governor, okay, conditions of shall not commit any illegal activities, including any activities in breach of peace and law and order. Violation of breach and return the case the bail petitions and disposed of. It will be the same order in both the petitioners and the petition. Let it be. Ten eight. 10-8. 13-8. How come? Trial. How many witnesses examined? Do you have feedback? Only one. Not very, not very relevant. Not very relevant. So, not very relevant. This is part of the notice, this one. reasons of arrest. Because this is inadequate, but this is detailed. This is past. Okay. You said 48, she says 48 is not there. 48 has to be cross-checked from here. You have you have marked also. How? Hmm. How many witnesses are listed in the charge sheet? Then no, it's complete. PW1 is complete. Decline. Process decline. Not available. He has not stated anything. Say PW2 also. This is further result. This is result. Hmm. We have to give 48 notice. This is fairly detailed. 48 notice. Same day. Wrongly. And so he was arrested on 10th and produced on 10th only. I think this is fairly detailed. I think it was given by electronic way, electronic method, electronic mode, electronic mode to the concerned police station. It was received by J. Sinha. J. Sinha is a family member. What is the name of the accused? Pradeep Kaur. Huh. It was delivered to the by wireless message to the concerned police station to be given to the received by J. Sinha. I think this will do. Then we'll have to go into merits. Then we'll have to go into merits, you know. Much more the 20 kg is the commercial quantity. On merits, so it will be difficult. He's in custody since. Hmm. No, 37 is there. 37, that has to be, that barrier has to be passed only then. Otherwise, since the notices are appear to be fine. Can I see the statements of the Caesar witnesses? CD is here, no? CD. Just a moment. What are the names of the Sida witnesses? Abuddin Mazumdar I found. Viswajit sir. Let's support it. Viswajit sir. Let's support it on similar lines. Merit will be difficult. 37 comes into play. Have a third, your good name, please, madam. Ma'am. Learned counsel for the petitioner. And K. Boyso, learned additional P. Invoking 483 BNSS. The petitioner herein, Pradeep Kaur, is seeking regular bail in connection with NDPS case number 87 of 2025, arising out of Silchar PS case number 811 of 2025. Full stop. He was arrested on no. The petitioner is in custody after his arrest on 10/8/2025. Full stop. The 11/8. Full stop. Oh, okay. The the allegations in the affair was that an information was received about suspected drug peddler coming in a Ertiga vehicle from Tripura towards Lamding Silchar Road to deliver contraband in Kasar district, whereupon GD 192 was made and search operation was late in the afternoon. One white Ertiga vehicle bearing registration number AS11CD 6925, suspected to be fake, was stopped, and the driver, identified as Pradeep Kaur, was searched, and inside the vehicle, 61 plastic packets were found containing 362.02 kgs, including packing of suspected ganja. Subsequently, after completion of investigation, charge sheet was submitted against the accused person. And 10 witnesses are listed in the charge sheet. Charge has also been framed, and the case is at the stage of prosecution evidence, and so far PW1 has been examined and PW2 examined in part. The learned counsel submits that while notice under section 47 BNSS is in order, but notice under section 48 BNSS has not been given, yeah, has not been given properly. The scanned TCR has been received. The prosecution submits that the accused was produced on 11/8/2025 as revealed by the endorsement made by the magistrate. I have perused the notice under section 47 BNSS and same and the same narrates the grounds of arrest in reasonable detail. The notice under section 48 BNSS is also available, and the same also is in reasonable detail and narrating the grounds of arrest pertaining to the accused person. The said notice was sent by wireless communication to the concerned police station to be furnished to the family member, and it was received by one J. Sinha. Therefore, in my considered view, there are no infirmities in the notices under 47/48 BNSS. Considering the considering that penal provision pertaining to commercial quantity of suspected ganja has been given, the rigors of section 37 NDPS Act has to be tested. For this purpose, I perused the relevant portions of the scan report. Two seizure witnesses were stated to be present at the time of the alleged seizure of the contraband, and both the seizure witnesses in their statements have supported about the seizure of the large quantity of ganja. Forensic report has come, right? Have you seen the FSL? It is submitted by the prosecution that the FSL report has returned a positive finding regarding cannabis ganja. In view of the yes, I've seen. This is the one. In view of the aforesaid materials, including the framing of charge against the petitioner, it is not possible to hold that the test of section 37 of the Act is passed in favor of the accused so as to overcome the statutory bar upon granting of bail. In the said facts and circumstances, at this stage, the court will be statutorily barred from granting bail to the accused, and accordingly, the bail petition stands rejected at this stage. It is hoped that the learned trial court would endeavor to expeditiously conduct and complete the remaining trial, considering the fact that the accused is in under trial detention. Okay, let's hope that helps. Yes. Next. What is this matter? POCSO? No. Not POCSO. It's a 302. It's Let's wait for a little bit. It is submitted by prosecution that the scan TCR as called for is not yet received. Issue press requisition. The learned counsel for the petitioner, drawing attention to page 50 of the bail petition, submits that co-accused was granted. Co-accused being the co-accused Neki Bali was granted bail by this court by the order dated 11/12/2025 in BA 3831 of 2025. This is the matter on. We have it. When do you suggest? Before vacation, before the holidays. You can suggest a date. We have 2 short weeks. Next week is 4 weeks, and then thereafter it's 3 weeks, 3 days only. Second, first or second? 4 is Saturday. You want to fix it Saturday? No problem. Third is holiday, Good Friday. Second, we can fix 1 or 2 matters on fourth also. Second. Let it be on second.
Delivery of judgment. Prohibitions petition 1608 of 2025.
For the reasons stated in the judgment, the instant criminal petition stands dismissed and disposed of.
Hearing item number 5.
Earlier order was also it is mentioned. Interim order was not extended. He's on interim. Last 3 orders, it was not extended. Candidacy is also received. Hmm. Right. On 4/8/2025, the petitioner was granted interim bail. From that order, you take this para 1, 2, 3. Para 1, 2, 3. Para 1, 2, 3 you can take. Scan TCR was called for and received. Full stop. But the allegations are serious. No? The medical report indicates grievous injuries. Full stop. Subsequent to grant of interim, the petitioner appeared before the IO, and his statement has been recorded. Full stop. Full stop. Statement has been recorded. It is in the K. Boysa learned additional PP submits that in the meantime, investigation stands completed, resulting in a charge sheet, and subsequently, the case has proceeded as charges have also been framed on 25/2/2026, and cases are the stage of evidence. In the given facts and circumstances, the interim bail is hereby made absolute, subject to the condition that he shall be available for the remaining trial, and he shall not hamper or tamper with evidence. Violation of bail conditions might entail cancellation of the bail. Bail petition stands allowed in this court.
Item number 6.
It also will be similar. Not my order. Egypt. On 31/10/2025, the petitioner was granted interim bail. From that order, you take para 2(3). 3(4). Close to. Is submitted by the learned additional PP so that in the meantime, upon completion of investigation, case has resulted. Upon completion of investigation, charge sheet has been submitted by CS number 11 of 2026, dated 31/1/2026. In view of the completion of investigation, it may not be necessary to cancel the interim bail. Accordingly, the same is made absolute, subject to available for trial, not hamper or tamper to the same conditions.
Item number 7.
In this case, I think you are not appearing. Kotakur is not appearing. None appears on behalf of the either sides. Also, the petitioner was granted interim bail on 28/11/2025. And case diary was called for. Issue price requisition for the case diary if the same is not received by the special PP or wildlife grant. Mr. I. Botago. Interim bail granted by the order dated 28/11 stands extended till the next date of listing. This is the matter on 204, 28th April.
Item number 8.
Hmm? 8, 9, 8, 10, 11. Page. Right. You take it from there. Just preparation for decoy. No? They were charged with walkie-talkie. Oh, will it be possible to take a different view since it's an anticipatory bail? I don't know. At that time, we thought it is serious. I don't know what is the stage now. Investigation is completed. Not yet completed. Mhm. That's okay, no problem. Mhm. Now, if it was a regular bail, it was slightly different, but it's an anticipatory bail. So Spatulate with me when I'll read it and you can take this. The aforesaid learned counsel fairly submits that an earlier bail petition was rejected on 9/1/2026, passed in AB 68 of 2026. From that order, which is available at page 24 of this bail petition, 2 and 3 paragraph we can take. 2 and 3. Investigation is still going on. The updated case diary is received again. Updated case diary is received again, along with a fresh bail objection. This I've seen. So, peruse the grounds of rejection narrated in the previous order dated 9/1/2026. What is the progress? Not much progress. Then one. In the endorsements in the case diary, the endorsements and notings in the case diary after the date of last rejection. Investigation is still in progress and not yet completed. In the circumstances, I am unable to find sufficient new grounds to take a different view in this subsequent pre-arrest bail application. Therefore, the bail petition stands rejected at this instance. Return back the case there. Same order, 8, 10, and 11. Same order. Someone else is there, otherwise you get overloaded.
9.
Adjournment. Okay. Updated case diary is available, but learned counsel for the petitioner seeks an adjournment. An adjournment slip has also been sent. This is the matter on Friday, 27/3.
Matter number 12.
Yes. Can you just check the microphone hearing? Just sometimes the adjustment requires some time. I just go away. No, you speak normally, but they will adjust it. We should not strain our voice, just speak normally. They will adjust the amplification. Anyway, so what are you saying?
Lordship, this is an anticipatory bill application and the eligible sections are criminal conspiracy, then extortion, criminal trespass, and few more other sections. Lordship, CD may call, and also I have a small request. There are 2 more similar matters, that is AB 286/2026 and AB 492 of 2026 were fixed on this Friday by this honorable court and CDB call. Lordship, kindly this matter also be taken up together. Meanwhile, Lordship, interim may be considered because in this instant case, there are several other co-accused who were granted bail by this honorable court, Lordship. One.
This case matter. Acha, you've received the CDS. CD is available by I you received the CD. 2 days on. Today is Wednesday. Day after tomorrow. Hmm?
If I may, actually, this instant application is wrongly listed in the bail hearing column. This is supposed to be the first day. So CD
Oh,
was
first
never
day.
called for, yeah. Yes.
You have received the CD in connection with the other matter.
That might happen, my lord, because.
Wrongly listed. It's a motion. Motion actually.
It should have been in the motion
Yeah,
column.
I think, I don't know what is the applications. Will it be okay if I just fix it on Friday? That date can be disposed of. No? Because otherwise, we'll have to go inside otherwise. And if you have, this orders of, co-accused or other.
Yes,
bring
Lordship.
the- one or two of those orders. It will help, see. Yeah. Your good name, please?
Lordship M. Bhuya.
I'm Real Learned Counsel. Commissioner. Submits that, this matter has come today for the first time. And connected bail applications are fixed for case diary on Friday. Nevertheless, call for the case diary of CID PS case number 20 of 2020. Achha, we had dealt with this.
Because my lord, that's within the other case to.
And, list on 27/3/2026 along with AB number. You can
AB
give the number.
AB 286 of 2026 and AB 492 of 2026.
Come to that.
Obliged, Lordship.
Should I mention about case diary? Not necessary. Cannot, it does not come here. It's first, first oath.
Body,
Please, my lordship, and this matter, a notice issued upon the respondent has been served and the name of the advocate of the respondent has been shown in the costly source.
You're appearing. Appeal against acquittal.
Yes,
You're for the complaint.
I'm for the complainant.
Also, yeah, you're.
He was accused and he was accused
agree
in the
with the
trial
accused.
court.
Any important judgment regarding, the scope of the power of granting leave?
Yes.
While acquittal.
Yes,
Huh?
latest judgment was
What is your take? You are opposing? Also, you want to file? File it. And, we will look at the case law.
yes.
So you. Stop. You are Mr.
P. Thakuria.
T. Thakuria, Learned Counsel for the leave petitioner
Yes.
seeking leave to file a criminal appeal against acquittal on behalf of the complainant. Vis-a-vis judgment and order of acquittal dated 6/12/2024 passed by learned JMFC Golaghat in CRNI case number 28 of 20. Learned JMFC, learned CJM. Learned Counsel, Mr. A. Gaya, Learned Counsel, appears on behalf of the acquitted person and seeks time to file a written objection. Prayer is allowed. This is the matter after Bihu vacation.
Yes,
This is the matter after the Bihu vacation on a date to be fixed by registrar.
yes. Masum.
16,
Last matter.
May I please, your lordship? But the petitioner seeking the leave of this honorable court to file an appeal
Same.
against the judgment of acquittal, my lord.
GR case.
CR case, my lord, check
C-
bounce case.
CR. Yeah, CR.
Yes.
That's why you need the leave. Can I?
Act, my lord.
Okay, you already appeared.
Leave is between the court and the petitioner. Who is asking for leave to file appeal against.
It is between the,
At this stage.
you have nothing to say. But so earlier order is actually not very correct. Then he's taken permission to file a objection. That's why Mike sir was also asking in a division bench that what is the, because I have not, I don't remember reading any major judgment on the scope of the power of granting leave.
Yes, ma'am.
374 is there.
Hmm.
Chairperson.
Case law. So let him file that. N. Uddin, learned counsel. N. Chaudhary, learned counsel for the respondent number 2/acquitted person. The invoking 419 subsection 4 BNSS. The applicant Kamal Boysu, who was the complainant in CR case number 49 of 2018 under NI Act before the learned trial court within bracket SGJMS number 1 Kamrup M second bracket is agreed by the judgment and order of acquittal dated 8/9/2025, whereby respondent number 2 was acquitted. He is seeking leave to prefer a criminal appeal against the said acquittal. Ms. N. Chaudhary, learned counsel, appearing on behalf of the respondent number 2/acquitted person, submits that the aspect of such leave would be between the applicant and the court. Very interesting. I've learned from you. Still, I'll just still ask you just one line, You think the appeal is, the judgment is wrong? Acquittal judgment?
Yes, my lord. Seven number of check was issued, my lord, and 6 number of check dishonor, the signature was different. And one check, my lord, that was, the amount was dispute in words and in number was something different.
Is submitted by the counsel for the applicant that he has merits in the appeal sought to be filed against the order of acquittal. The leave for filing the appeal is hereby granted. The instant criminal leave petition is disposed of according. The criminal appeal is already numbered.
No, my lord, it will be
Cannot
numbered.
May be
After-
numbered and put up for admission.
Yes, my lord.
Copy may be given.
Copy of the appeal.
And in appeal, my lord, their name may be shown, my lord, because they have filed Wakalatnama in IA. Perhaps if IA disposed of, and again we have to issue, send the notice. So,
The copies of the appeal may be furnished to the learned counsel appearing on behalf of the respondent/acquitted person. Full stop. And the name of the learned counsels for the said party may also be shown in the
cause list.
cause list while listing the appeal for admission.
Yes, my lord. I will serve a copy, my lord. Oh. Vice President.